I'm not, there we are. Okay. So there. So how's everybody doing today? So say hello. And remember to give Facebook permission to post, for StreamYard to post on Facebook. Okay, so that your name can show like this. Otherwise, it won't show a name. Okay, and let me get my other computer, showing it on the computer, put that off. All right. So the source that we use every one of the times, okay, is this one here for glossary, vocabulary, terms, definitions, okay, whatever you want to call them. It's the Texas Real Estate Sales Exam. It's one of the sources that I use, and the reason why I love it, it's because it has the table of contents with 1, 2, 3, and 4 exams and a little test preparation. And the book is by Learning Express, okay? And it gives you a little preview about what the real estate exam is, a refresher, math review, and of course the vocabulary. And so the vocabulary is what we start off with every day, every time, so that you can be well versed with that since you're learning a new language. Okay, and we left off, or we were starting off with negative amortization today. Okay, and then on the Facebook page, there's also material that I uploaded with acronyms, different types of acronyms, okay, that you can review, math. So look at the sources on our Facebook group. If you're on the group, there's a lot of information in there, a lot of attachments that I added, and the source that we use is also in there. Okay, so be relaxed, focus, pay attention. Let me make sure that my phone is on do not disturb. Okay, yes it is, so that it doesn't ring while we are in class. Okay. All right. So at any time, feel free to ask questions. If you're on YouTube, you can also type comments on there. So I'm broadcasting to YouTube AgentPrep, as you see on here. I'm broadcasting onto the Facebook group. Okay, and I'm also broadcasting to my personal Facebook page. So with that said, we will stream. Okay, we're going to start off with negative amortization. We'll spend about 30 minutes on vocabulary. Then we'll go into national questions, and after that into state questions. Okay, so let's get going. Negative amortization occurs when an adjustable rate mortgage is allowed to fluctuate independently of a required minimum payment. A gradual increase in mortgage debt happens when the monthly payment, is not large enough to cover the entire principal and interest. The amount of the shortfall is added at the remaining balance, so it's added at the end of the loan. And so the loan keeps getting larger, okay, until they end up being able to make the full payment. So negative amortization and adjustable rate mortgage, ARM, right? It stands for ARM. So it fluctuates the required minimum payment. Gradual increase, all right? Gradual increase on a monthly payment. Okay, net income. The income produced by a property calculated by deducting operating expenses. So all the costs for operating an expense, a rental property, okay, commercial property, a residence home, whatever your monthly expenses are, you subtract those from the income. So as well as rent. So the net lease, okay, is also something similar to that. So the net lease of lessee, okay, that's the tenant, is paying for maintenance and operating expenses. And that operating expenses could be the utilities of the property. If it's a triple net, then they'll have to pay taxes, insurance, and maintenance and utilities. So that's called a triple net lease. All right. Net listing. Although they're legal in Texas, we don't really use them, okay? Because that's where a realtor could end up being dishonest and not looking out for the seller's best interest. But it is a listing in which the broker's fee is established as anything above a specified amount to be received by the seller from the sale of the property, okay? Net worth, the value of a person's assets, all of the person's assets. So any assets that you have, being your house, your cars, your investments, cash in the bank, your retirement, CDs, 401k, all that is considered your net worth. I'm going to lighten my ring light a little bit. It's a little bright. Okay, then no cash out refinance. So when you have a loan on your property and now the interest rates have decreased and you want to take advantage of at least a 2% decrease, that's the best time to refinance. However, you're not going to cash out. You're just doing it to reduce your payment and by reducing the interest rate. Then it's a no cash out refinance. A refinance transaction in which the new mortgage amount is limited to the sum of the remaining balance of the existing first mortgage. So it's a good thing to do instead of taking out a lot of money from the equity, is to just do a no cash out. When people do reorganization of their debt, or consolidation, I should say, they will end up getting a refinance loan and take cash out to pay, other debt. Well, now you're paying for the house much longer and much more money. Non-conforming use. So it doesn't conform to the norm. A use of land that is permitted to continue or grandfathered even after a zoning ordinance is passed. That prohibits the use. Okay, so let's say there was a little business, okay, and that area was now being converted into residential, but the commercial business, a store or shop, was there. So it is grandfathered in. It is not a non-conforming use because the zoning changed. So it stays grandfathered in until it is not necessarily sold, but until it's torn down and rebuilt, then it has to meet the new zoning. Non-liquid asset, an asset that cannot easily be converted into cash. So a house is, not quickly converted, okay? And so it's not, cash right away. You can take cash out of your checking account, your 401k, other things like that, and you can convert to cash quite easily. A house you can't, unless it sells in one day, right? And you get a cash deal. Notarize, to attest or certify by a notary public. So all the title companies, the escrow officers, they are also notaries, right? Because they have to witness the sellers and the buyers signing all the documents at closing. Note, not that you're writing a note, but it is a note that we write. But it's acknowledging a debt. Like in the old days, we would say, I promise to pay you, and you could write it on a piece of paper and both of you sign it. Well, now that promissory note is similar. It's not recorded. And so it's a written instrument acknowledging a debt with a promise to pay, including an outline of the terms of repayment. Again, promissory notes are not recorded, okay? The warranty deed and the mortgage are. Note rate. So that is the interest rate on a promissory note, on the loan, okay, that the buyer is getting from the lender. So the interest rate, that is the note rate. And so it'll be in the note, okay, the promissory note, which is a promise to pay. And it'll also be in the, I think on the deed of trust. Now, and on the documents at closing, okay, showing all the terms of the loan. And so it's going to show the traditional interest rate, and then it'll show an APR, which is the annual percentage rate. And that annual percentage rate is going to include the cost of lending. So who else is here on Facebook? Say hi. There's two of you, and then you keep changing. Oh, that's weird. I have it as, wait a minute. I need to correct that. I don't want to be showing up as, let me see if I can change that, because I'm no longer with Keller Williams and it's showing up with Keller Williams. So I reactivated after attending a session. I reactivated my, let me see, comply. Well, I can't change it right now. I reactivated my business page, okay, from hearing one of the coaches, because Facebook won't let me change my name. So I have two business pages, okay? And all right, so the next one is a notary public, okay? So the notary public is the one that notarizes all the legal documents, and they are at the title company as the escrow officer. So hold on, I'm going to go to my, hold on, I'm tinkering over here with, I got out of the Facebook group page. And I want to be able to comment as, let me see, I think I can change it here. You know, sometimes we get so darn tired. I want to be able to comment as, hold on, I need to turn this off here. It ended up coming on the video because I have Facebook on my computer so that I can see whoever is commenting. Okay, so I have multiple not screens, but screens going on at the same time. All right. So the notice of, so the note rate, the note, the notary public, I was going backward. Notice of default. To comment as, okay, I just muted it. Notice of default, a formal written notice to a borrower that a default has occurred on a loan and that legal action may be taken. So the deed of trust that we have in the state of Texas, instead of a mortgage, we have a deed of trust. And there will be a notice of default. What happens when the borrower defaults? So it's a written notice to the borrower, and it'll come from the trustee in the state of Texas because of the deed of trust. In another state, it has to go through the court system to get approval from a judge. And so that is a judicial type of foreclosure. In Texas, we have non-judicial. So the trustee will perform the notices of default that are sent out to the borrower. Novation. So it is something new. The substitution of a new contract for an existing one. The new contract must reference the first and indicate that the first is being replaced and no longer has any force and effect. So let's say we've got a contract and we're doing a counter. So in the counter, we'll say, in Texas, we can, strike out on the contract, make the change, and send it back for initials. Or we can wait and do the countering through email and then finalize the contract, okay, or create a new one, okay, real quickly. And I say real quickly, but it depends on how well you know the software. But it can usually be, once you do a lot of transactions, you can do it quickly. So the counter offer becomes the new contract, even though it was the same contract, but because there's a counter, it's being replaced by new conditions. Even if it's only one condition, it's still considered a new contract, substituted from the initial one. So it substitutes, it takes over the prior contract. Obligee, double E, right? Person on whose favor an obligation is entered. So they are the receiver. Oh, no. In this case, this is like the mortgagee. Person on whose favor an obligation is entered. So the obligee is the mortgagee. The obligor, the person who is bound to another by an obligation. So the obligor is the mortgagor that is obligated to pay the lender, right? Who is the mortgagee or the obligee. And it could be a private owner that provided a personal seller financing type of sale. Obsolescence, a loss in the value of a property due to functional or external factors. When the obsolescence is functional, that means the house is outdated. The neighborhood now has 3-bedroom homes, and this one is 2 bedrooms, or it's missing a bath. So the functionality is obsolete. It's going to take quite a bit of cost. It can be repaired, but it's going to take quite a bit of cost in order to bring it to the comps of the surrounding properties. Others are environmental factors that no matter what they do to it, it's not going to improve the value. It's environmental or external factors. It's called 2 things, environmental and I forget the other term, but it's external factors. The surrounding areas changed. It became a busier commercial place. They installed they built an airport, a hotel, or others that is going to impact the value of the property. And no matter what is done, it's not going to improve the value. So it depreciates the value. So that one, it's external factors that impact it. Can't do anything about it. But the functional, yes. And then there's physical obsolescence, which it just needs to be updated. The functionality of it is still good, but it needs painting, new flooring, countertops, things like that in order to come to par to the new properties, the new models, new homes. Offer, to propose as payment, bid or property. Okay, like on eBay and other auction websites, you're making bids, right? So same here. So there's competition. And, some people buy homes in auction websites and they have to deal with the bidding process and be prepared to purchase. Offer and acceptance. And usually there's, a time frame, a week, 2 weeks, or something like that. So hi, Anna. Sorry, I never said acknowledged you. You said it will or will not impact the value. The functional does impact the value. The external does impact the value. And there's nothing you can do to the external environmental factors. Okay, so if a water treatment plant or if a business moved in next to you, if the airport was built, a new expressway, like when I was growing up, they did a new expressway in front of our house. Well, we can't move the expressway. No matter what we do to the house, it's not going to improve the value of it. That's what I was talking about. So it does impact the value. The functionality of the house, if the new homes, let's say investors are tearing down old homes on the lots and building new homes, well, that other little house is no longer functional because the new ones are 3 bedrooms, 2 bath, 4 bedrooms, 3 bath, and this one is maybe a 2 bedroom, 1 bath. So so that functionality of that house is obsolete. To bring it up to par with the other homes, it's going to take a greater investment than just being cosmetic, physical. So externals can't do anything, okay? You could tear it down and make it a commercial property. So that's another thing. Offer and acceptance. So we were talking about novation here. When there's a new contract, an offer, and there's a counter, then it becomes a new one. So you have an offer and acceptance, two of the necessary elements for the creation of a contract. So a buyer makes an offer to the seller, the buyer agent presents it to the listing agent, and the listing agent presents it to the seller. The seller will either accept, counter, reject, or sit on it. So they have 4 options, okay? Accept, counter, reject, or sit on it. And sit on it, it's like, okay, they're waiting for maybe the buyer to come bring a better offer instead of them countering. In some states, there is a time limit on when the seller has to reply, or also the buyer on a seller counter. Once it's accepted by all parties, then it is executed. Like last night, I executed a contract on a listing that I put up Sunday, got an offer on Monday, and then I was going to get 2 other ones, but those buyers were hemming and hawing. So in the process, okay, we did a little bit of a counter. So it was kind of new. So we waited for an agreement. And then yesterday we got an agreement on it. My seller signed the new addendum and I executed the contract because we were the last ones to sign. Okay. And I sent that to the buying realtor and to the title company so that they could open escrow today and get it done before 4th of July. Open-end mortgage. Open-end mortgage. A loan containing a clause that allows the mortgagor to borrow additional funds from the lender up to a specified amount without rewriting the mortgage. So sometimes these are home equity lines of credit. They're like revolving account. They're open-ended. So we can use it kind of like a credit card, pay it down, pay it off, and reuse it again without writing a new mortgage. Now, the home equity lines of credit, abbreviated as HELOC, H-E-L-O-C, those may have to be redone after 1 year or 2 years if the rates happen to change. So they're good for a few years, and then the lender says, well, you know what, the interest rate changed, we want to make a little bit more money. So you have to reapply for that home equity line of credit. Open listing. So before we had net listing, right? So net listing, it's legal in Texas. However, we don't use them. Open listing. So a net listing would be in writing, okay? And it's accepted by the buyer, by the seller and the broker. However, it's not advisable, and most brokers don't allow it. Open listing is that seller can go to a bunch of different realtors and say, hey, I want you to bring me a buyer and I'll pay you a commission. But then they go and do the same with another realtor and another realtor. So they want all the realtors to advertise for them without making a commitment to be committed to just one. So it is open. It is not in writing. It is verbal. So a listing contract given to one or more brokers in which a commission is paid only to the broker who procures a sale. If the owner sells the house without assistance of one of the brokers, no commission is due. So in an open listing, we as realtors, what do? We start marketing a property, right? Because we want to attract a ready, willing, and able buyer. However, we could be doing a lot of work, so could other realtors, and we don't end up making anything unless we bring the buyer. Opinion of title. So an opinion Okay, they're typically opinions, usually given by an attorney regarding the status of the title to a property. So they do a research on the chain of ownership of the property, chain of title, and then it's provided in writing. And it also they'll find whether there's any judgments, any liens, any lawsuits, any other debts that are attached to that property. But it is an opinion of title. Anything that's recorded, of course, it's public information. That one is not an opinion. So a buyer or a seller can go to an attorney and have them review that title commitment, okay? So that the attorney can translate it for them or explain it clearly for them. Option, an agreement that gives a prospective buyer the right to purchase a seller's property within a specified period of time for a specified price and for them to buy. So the optionee, one who receives or holds an option. That's the buyer, right? The optionor, one who grants an option. So the property owner, the seller, the grantor. Ordinance, a municipal regulation. So there's city ordinance, county ordinances, okay, and those are public record. And we typically have to go to an office to get those or Google them on the county website, city website. Original principal balance. So that's the original loan balance of a mortgage. The total amount of principal owed on a loan before any payments are made. So if the borrower borrowed $300,000, that's the original principal balance. Okay, every time they make a payment, the principal is going to reduce a little bit. The interest rate, and I say a little bit because the interest rates are usually higher. Right now it's really low. So, very little money is going towards the interest. So a lot of it is going towards the principal, which is the actual loan amount owed. Origination fee. This is what lenders will charge. Not all of them charge an origination fee, but that can be 1% or 1.5% of the loan amount, not the purchase price amount, but the loan amount. So the amount charged by a lender to cover the cost of assembling the loan package and originating the loan. Owner financing, a real estate transaction in which the property seller provides all or part of the financing. So instead of a lender, if you see a for sale by owner, it doesn't mean that they're offering owner financing. It means they're not using a realtor. This type of owner financing is the owner, instead of is going to provide the buyer with the option to purchase it with them. They're not actually giving them the money, but they're the bank. And so then the borrower ends up paying the owner the monthly payments just if they were paying a bank. And so a deed of trust is created with a vendor's lien and also the promissory note. But the seller is going to be the one, and the title and the warranty deed, are conveyed. If it was a land contract, the warranty deed would not be conveyed until the note is paid off, the mortgage is paid off. Ownership, the exclusive right to use, possess, control, and dispose of property. Okay, ownership, the exclusive right to use, possess, control, and dispose of the property. So that's having all the bundle of rights, right? Okay. There's very little attendance tonight, so I'm going to end up cutting the class short and do it just 1 hour. So I'm going to go ahead and move into national questions now and do about 15 minutes of that, and then do some state questions after that. So let me write a note as to where we start next time. So holidays, everybody's getting in the mode of holidays. 4th of July, fireworks, celebrate. So we will start on package loan, package mortgage. Okay, on page 172. Okay, so for national, I'm using a different source. Let me show you that. So this is a second source that I have. This is the most, was created last year in 2020. So the Texas Real Estate License Exam Prep. Okay, it's a third edition. And I like this source again because it has multiple exams available. Okay, so it has your introduction and overview. It goes through national law and all the different types of where you would be dealing with national law, right? Estates, ownership, encumbrances, transferring and recording, so very important. And then real estate math cramp cards, Texas law and regulation, section 3, then the national practice exams. Okay, this one has 10 tests. And then the Texas state level practice test has 16 of them. Now, these are not as long as on the other source. And then it has a long Texas license examination sample test, which will have the national and the state. Okay. And with this, we're starting on page 138. All right, we're starting with question 2.18. All right. So let me see if when I enlarge it, yes, you get to see it all. What I like is when you can still see it even larger. Let me do the, all right, but now, see, unfortunately, because I want to make sure a lot of people view this on their phone, and so you can't see the question. Well, I'm going to go back to where I had it. That still didn't work because I changed the size of the font, right? Okay, well, number 18. So these are national questions. So remember to participate. When you answer the question, make sure you write the question number and the answer, okay? So we're with national questions. All right, number 18. On two adjacent properties, there is an easement that allows property A to use the driveway that belongs to property B. Here, property A is said to be which of the following in relation to property B? Okay, so you have a servient and you have a dominant. So, see, oh gosh, I hate that. So property A, let's see, the easement allows property A to use the driveway, but it belongs to property B. So in this property, property A is said to be what? Are they the servient or are they the dominant? Okay, remember you have servient party and the dominant party or tenement. Which one is it? Owner A or property A, property B. Property B is the owner, property A is the one that has access to the easement. I gotta view this on my phone to see if it's big enough. So remember to post your answers. Remember to post your answers. Okay. So I give you time so that you can post an answer, type your answer. Hold on. So, oops. Okay, so that's question 218. So anybody trying the answer? So is it a servient tenement or is it the dominant tenement? What is A? So property A to use the driveway that belongs to property B. So the one that has the right to use it is A. What are they called? Okay, it looks like nobody wants to try. So the answer is D. It is the dominant party because they're the ones that have access to it. Okay, number 19. A property owner who is selling her land wants to control how it is used in the future. She might accomplish her aim by means of, so she wants to control how it is used in the future. She can do that how? With an injunction, B, a deed restriction, C, an easement, or D, a land trust. So how can a property owner have more control over the use of the future on their property? So they're selling, let's say, a large tract of land, and she wants to have control over the use of it. Okay, the answer is B, a deed restriction. It's funny, I was going to type the wrong letter, even though I had the right answer mentally. Okay, so the answer is a deed restriction. The city has the zoning and its own restrictions. However, if a property owner is going to do a development, they want to control the use in that neighborhood. Let's say they want all 3-bedroom, 2-bath brick homes, 1-story, 2-story, then they'll put deed restrictions and record those. So that was number 219, B, deed restrictions. Okay. Okay, number 20. What distinguishes a lien from other types of encumbrance? A lien from other types of encumbrance. A, it involves a monetary claim against the value of a property. B, it lowers the value of a property. C, it is created voluntarily by the property owner. D, it attaches to the property rather than to the owner of the property. So a lien versus an encumbrance. So here, definitions, of course, is important. All right, the answer is 20A. It involves a monetary claim against the value of a property. A lien is financial. Encumbrances is something that is a cloud on title. It's not necessarily financial. It could be a fence overlapping onto their a fence that's not on the boundary line. Hi, Jesus. Or it could be a shed from the other owner that's into their piece of land. So that's an encumbrance. Easement. It can be an encumbrance because it is attached to the property and it goes with the land. Okay, so number 20, I already put the answer right. A. Okay, how's it going, Jesus? Number 21. Gosh. I work at accommodating how to fit this on here. But it doesn't always work. So number 21 is still not showing all on one page because it makes it difficult for you all to, oh, that's really big. Let's go down a little bit smaller. There we go. Okay, 21. Which of the following defines actual notice? A, it is notice published in a newspaper. B, it is knowledge one could have or should have obtained. C, it is notice explicitly stated in a legal document. D, it is knowledge received or imparted through direct experience. So when we say there is actual knowledge of something, is it because it's published in a newspaper? It's knowledge that you should have obtained? It's a notice explicitly stated in a legal document? Or it is knowledge received or imparted through direct experience? Okay, the answer here is D. It is knowledge received or imparted through direct experience. So let me explain this one. So the term notice is synonymous, strongly suggests an idea with knowledge. A person who has received actual notice has actual knowledge of something. Receiving actual notice means learning of something through direct experience or communication. Thus, a document in itself cannot be actual notice. It is the seeing of the document that makes it actual notice. The same with a contract. So a contract is said, even though it's been signed, okay, by one party and it's been sent. However, the seller hasn't received it, even though it's already on paper, but the seller doesn't have actual knowledge of it, hasn't seen it, then the buyer could still terminate that, or vice versa, okay? Until it's received, then that's actual notice. Okay, we have 10 minutes left. We're going to go into some state questions. Okay, so we will start with number 23 next week. Number 23 on page 139. Okay, and the answers, and I have to keep track of where the answers are on page 245. And this is on my Kindle. Okay, so let's do 9 minutes of state questions. Okay, so come on. Oh, there we go. Okay, so on state questions, I think we finished on number 93. I couldn't remember. Oh yeah, we did do this one. So maybe it was, like I said, 97. Okay, so we're starting out with now state questions. All right, number 97. So change your thinking cap. Okay. Oh. Hold on, I'm adjusting my screens on another page. Another monitor so that I can see the Facebook page and then. Oh, sorry. I'm showing you the answers. I don't want to do that. Oh my goodness. I want to show you the questions. So very funny, Lily. Okay. These are the questions. Even though it says answers up there. So let me go to question number 97. Oops. Okay, on this book, questions 81 through 110 are state questions. Okay, number 97. It's a long question. Salesperson Sydney failed to complete his mandatory continuing education MCE classes prior to expiration date of his current license. On the 5th of the month following, his broker on the 5th of the month following, he brokered a deal worth $30,000 commission to him after the brokerage company gets its share. So on the 5th of the month following, he brokered a deal worth $30,000 in commission to him after the brokerage company gets their share. So let's say it's a 20-80 split, right? So what happens, okay, when he fails to complete his MCE classes? A, even though Sydney sent his license fee to the state before the expiration date of the current license, he committed an illegal act because he had not completed the required education. B, fortunately, Sydney paid his license fee before the deadline and was issued a new license with a requirement to pay an additional $200 and complete the education within 60 days. Or C, Sydney committed an illegal act and is subject to a fine and denial of an ability to reapply for a new salesperson license. Or D, none of the statements are true. So Jesse says D. Oh my goodness. Okay. Anybody else? Right now, there are 3 of you on here. So what is he allowed to do? Sherry says B. So let's see. there is a true statement on here. Okay, so what happens when you don't complete your MCE classes? You can pay your renewal fee, and you will be allowed 2 months or 60 days to finalize the classes and pay an additional $200, okay, to complete the education within 60 days. So you're going to pay two fees, the renewal and a late fee, okay? So that's where it says pay with an additional $200 and complete the education within 60 days. So the answer is B. Very good, Sherry. Okay, number 98. Which of the following actions could leave a broker open to charge of participating law without a license? A, advising a seller that property is overpriced and therefore unlikely to sell. B, advising a seller that in the broker's opinion, title of the subject property is not valid. C, advising a purchaser to obtain a lawyer's opinion of title or a title insurance policy. Or D, adding factual statements and business details requested by the principal standard forms promulgated by the Texas Real Estate Commission. So which one of those would be acting as a practicing law without a license? So advising a seller that property is overpriced, I mean, we could do that, right? Advising a seller that in the broker's opinion, title to the subject property is not valid. C, advising a purchaser to obtain a lawyer's opinion of title. Yeah, they can do that. Or D, they're not practicing law. Or D, adding factual statements and business details requested by the principals. Okay, so that we do like in section 11, right? Special provisions. So Sherry says B, Jesse says D. And the correct answer, okay, is B. Lots of laugh. Yeah. 97B. Okay, I don't know if I showed number 90, answer for 97, right, was B. And then this is 98. And that too was B. Okay. So let me type it on Facebook. Okay, we're going to do one more question and we'll end for the day, or maybe we'll do 3 and finish this page. Okay, I'm going to cut the class short. Not a lot of participation. Parties can be compelled to take a dispute to mediation prior to being able to initiate litigation by a judge, B, the real estate real estate commission stands for TREC, right? A broker, C, or D, either party. Parties can be compelled to take a dispute to mediation prior to being able to initiate litigation by what? A judge, B, TREC, Texas Real Estate Commission, C, a broker, or D, either party. So 99. Happy 4th. Until next week. Bye.